Hello, everyone. My name is Frank, or Netpoet, and I would like to talk with you and to you and discuss with you subsequently a few aspects of a piece of legislation that you might have come across recently in the past years. Just for those of you who don't know, I'm an attorney. I'm a German attorney, so if we have foreign law questions, I might be a little weak on that. I have a law firm in Frankfurt. I deal with IT law, which includes data protection. Now, since I've been talked to about this by many people, just to make things clear, we're talking about the GDPR today, and I'm not here to talk about Article 13, 17 of the EU copyright protection, like copyright novel. I know I was thinking, like, when I talked to the organizers about what to talk about, I had already chosen the topic and then thought, should I switch? I didn't, for I think a good reason being that the actual election, the vote, is already cast. So on a European level, it's pretty much done. The only thing that you can do at this point is vote at the EU Parliament election coming up this May, like 23rd to 26th, I think. So if you're eager to do that, I can tell you I will. That's fine. But on a national level, there is still much to do. And at this point, it would be premature to tell you about concrete consequences that this would have. So I decided not to do that this year. I'm not saying we're never going to talk about it, and I'm happy to do that over a drink. But here, I would like to share a few things about the GDPR that many of you might have felt, might have even discussed with me or with someone else. I can tell you that these things that I'm presenting to you today are things that I talked to with other lawyers, that we discussed, that we're trying to figure out a way how to deal with it, and also pose the right questions. So you'll have two parts, basically. I will try to give out information that's important to everybody, no matter whether you are looking for concrete answers to concrete questions that I picked out, or if you want to discuss more on a meta level why we're doing this. You'll see there will be a second part in this. Now, just for the record, I'm not trying to rant about the GDPR. I know the title sounds a bit like it. I wanted y'all to come here. But I'm not trying primarily to rant, but I would like to pinpoint a few aspects that I think are essential when we're talking about data protection, about GDPR, and why it's come such a long way, and maybe even where we can go and move it from here. So, who of you thinks that, like, hands up, who of you thinks that the GDPR has improved something? It can be anything. Just someone who, I'm not saying that it has to be perfect. I'm just saying that who of you thinks that the GDPR has improved something? Okay, that's almost everyone, and Andri is still on his phone. So who of you thinks that the GDPR has brought negative consequences upon us? That's okay, you're doubtful, okay. Good, okay. So I can tell you that this perception is something that almost everybody has, and I can assure you that I've had it for years. I mean, we've talked about the GDPR for years and years, and now since it's there, I mean, we saw stuff coming. There is some stuff that we didn't see coming, but it's important to figure out that, of course, there are both sides to the story, and actually the GDPR is even more difficult to figure out because it's not just one story we're talking about. And I'm just telling you this as an introductory remark so you can follow along when we leave the concrete questions and just go a level above. Now, this is a little Germany focused because those are the majority of events that I stumbled upon. So if you're from Germany, it's very likely that you've heard about this. If you're not, I'll explain what happened. So, and I'm sure there will be tons of other things. This is just something that I stumbled upon. So first, who has heard of the Klingelschild Gate? Okay, so probably more the Germans. So what happened was, and it actually happened in Austria. There was a fight about the question whether your name, whether you would be entitled to have your name removed from the ring, like from a bell on your door. If you lived in a multi-story apartment, were you entitled to have your name removed because it was personal data? Are you entitled to have it removed? I'm not giving you a concrete answer to this. It has been widely discussed. What I'm just saying, I'm showing this because I think it illuminates quite nicely what kind of discussion we're having now. Another thing was Wunschzettelgate. It wasn't as widely discussed as Klingelschildgate, but what had happened was the city of Roth in Germany had, the administration, the city, had the idea to have a Christmas tree lit up in town and where kids could pin their wishes to. So you could write down what you wished for, and the city made some efforts so your wishes would come true. Now, obviously, since that is not possible otherwise, the kids would have to put their address and name there so the city would know what to do. So there's been a huge fight about this, whether this was great or whether this was even legal or not. I'm also not answering whether or not it was. I think there is just a lot of misunderstanding, especially when there are kids involved. Now, this is something else that I dug up on Twitter, and I'll translate it for the non-German speakers. At a Commerce Bank, there was this hung out saying, "Dear clients, for data protection reasons, it is not allowed anymore to provide a trash can to you." It was in the lobby somewhere. So we're now politely asking you to not throw out your trash in the lobby. Thank you. And in all honesty, what the fuck? But that is the sort of stuff that we're talking about. And as I've already mentioned, kids, let's just avoid the whole discussion about what happens at schools with, photographs of kids, stuff that parents will try to fight for or against. I'm completely omitting that because we're not going anywhere. This is not leading anywhere. I'm just telling you, it's absurd. So what I've done is I've handpicked a few hurdles that I feel when I work with or on the GDPR for clients. And just so you know, this is just a few concrete examples, and I've tried to pick a few that lead us somewhere. So I'm sure I am aware there are thousands of questions, and questions that I can tell you, not even attorneys, not even lawyers can actually really reliably answer. I mean, all of us, like the lawyers, and you don't even have to be a lawyer to have an opinion about something. So, but we can all have opinions, but sometimes, like in all honesty, when I talk to colleagues, they also don't know how to deal with this. So I've picked a few. Now, to begin with, what is even personal data? And the easiest thing would be to just look up the definition of it. So I've done this for you. I can assure you that you can read quicker than I can read it to you, but just to focus on the most important stuff, personal data means any information relating to an identifiable person. That's enough. It doesn't have to be identified. It's enough if it's identifiable. So to any data subject. We're talking natural persons, not at all companies. All companies' data is out of the scope, not at all interesting. But even if that person is identifiable indirectly, for example, by reference to an identifier such as an online identifier, meaning, for example, a cookie ID. So anytime, and we haven't even discussed about the question whether or how identifiable the person has to be. How much effort is viable? How much effort should we take into consideration for a person, like a data subject, to be identifiable? There are opinions out there that I have to take into consideration when I work in this. Let's say pretty much any piece of information is identifiable. So basically any information is personal. You've probably heard about examples like IP addresses being personal data, things like that, but cookie IDs. So, and I'm just saying this because when you use cookie IDs and you say, I couldn't care much less about what person I'm dealing with, I'm just giving it an ID in the cookie, I don't care who he is, you're still in it. So pretty much nothing you can do, unless you really don't measure anything, gets you out of the personal data scope. So it's very difficult, not even like the whole big data aspect. Most of that is identifiable in one way or another, or you'll have databases that may contain personal information, which means if you don't want to have two sites and have two infrastructures for both of these, you'll have to deal with all of this anyway. And what I'm saying is, this is the entry hurdle, or at least it's one. So whenever we have personal data, it's not technically correct, but we're almost always full on. When we have that, and it's not for like personal or household activity, that's what the GDPR states. So if you do it only for yourself, or you're like a family environment, close friends, something like that, you're in. And I'll come to why this is important in this talk too. So some measures that you have to take once you deal with personal data, as a company especially, are sort of on an appropriateness basis. But most of the things are just like you have to do it or you don't. And speaking of that, how far does the controller's accountability go? Meaning, the controller is the person, usually a company. Let's just say it's a company because it's easier, or like an association maybe. How far does the controller have to prove that they're doing everything okay? Now, just so you know, in Article 5, I'm always referring to GDPR. Like, I'll never say GDPR when I have articles, just so you know, this is always GDPR. So in paragraph 1, and I'm just flying through this so you have a rough idea what the scope of obligations is that you deal with whenever you have personal data and you're outside of your personal or household activity. All the personal data has to be processed lawfully, fairly, and transparently, whatever that means in practice, but that is something that you have to do. The information has to be controlled for specific, explicit, and legitimate purposes. So it all says, more or less in repetition, you need to be inside the scope of the GDPR and the obligations and the everything. And also, the personal data needs to be adequate, it needs to be relevant, limited to what is necessary, so you may never have more than you need. So that's data minimization right there for you, and it has to be accurate, it has to be kept up to date, which in many instances is next to impossible, but that's what it aims for. And also it has to be kept in a form that permits identification of the data subject. So you may, like, sometimes this is even counterproductive. You have to be able to identify the person. So when they approach you and say, I want erasure of my data, what do? You need to be able to identify them. So it's even an oxymoron in one way or another that you have to store more information on people so that you can identify them and do what they want to remove their data. And finally, you need to process personal data in a way that ensures appropriate security. So this is actually one of the cores of GDPR. But you see that data protection and data security is not exactly congruent. So it's somehow something different. Maybe one is part of the other, maybe the other is part of one, who knows? But all this. Now, you might think, well, okay, I mean, it's a goal. The GDPR aims for it, fine. I mean, it's a good goal, right? Because we want, of course, it has to be lawfully processed, because if you don't, well, what good does the GDPR do in the first place? Now, in Article 5, Paragraph 2, in one sentence, the vastness of this becomes visible, because it says the controller shall be responsible for and be able to demonstrate compliance with paragraph 1. And boom, in one sentence, and I love this, Alcama says boom all the time, I love that. So boom, you have about probably the biggest problem that the GDPR could give you with originally good intention right there in one sentence. Because it says you need to be able to demonstrate that you comply with all of this. And now, like if you're Google or Facebook or Apple, like what's it called, GAFA or GAFA? If you're big, that's sort of doable. It's difficult, but doable. But just imagine you're some little, like small, medium-sized business, and you try to prove that you have data minimization. How do you prove that your personal data is adequate, relevant, and limited to what is necessary? Okay, maybe. How do you prove? How can you even make sure that the data that you have is kept up to date? Just imagine some newsletter subscription model. You're supposed to do what? Tell them that you have to be able to prove that the addresses that you have on the list is current and up to date? How? How far does this go? So what I'm saying is the accountability, I think, is a huge problem because sort of everyone knows that it cannot go as far as this, but how far does it go? What you have to, like when companies ask me how much do we have to do, I am in some way forced to interpret the law against the explicit wording. Because, I mean, there's no doubt really, you have to be able to demonstrate compliance with all of this. But even medium-sized businesses cringe when they see that, when they understand this, because it is, in many cases, absolutely, positively impossible to do all of this. You can be good, you can do your homework, you can go with best efforts, best practice, all sorts of things, but being able to comply and prove compliance with all of this is, as a matter of fact, impossible for many. That is a problem. And so there is a supervisory authority in Baden-Württemberg here in Germany that is actually quite active, and Twitter's too. So there are a couple of accounts on Twitter that I highly recommend if you're interested in this. But so the supervisory authority said last year in autumn, I'm summarizing with loss here, but it said, well, could the companies please stop just bombarding us with questions and just deliver solutions that are okay? And because they said, well, we're going to play along if it's okay. I mean, if you can justify what you did, it'll be okay. And I think, I mean, as good as that might sound, this doesn't help, really. I mean, for all things considered, the least that you have to do, even as a small business, is actually get an expert to tell you what's going on. And I think that alone is a problem, because when it comes to really basic stuff, basic obligations, in something as vast and something as big and long-reaching as data protection, you shouldn't be forced to get experts' opinions on things like this. Like in certain details, fine. We always interpret law. That's what lawyers do. That's what companies have to do. It's fine. Just like that, I don't know. I find that highly difficult. So I also mentioned this, like I touched this a little bit. Why does it matter what you're accountable for? Well, as long as you're, now you have to, like when you're trying to aim for 100%, let's say you aim for 80%, that's fine. But whenever you try to take measures, like for example, the technical and organizational measures, the TOMs, some of you, it's a standing term. I use TOMs all the time. So what I mean is technical organizational measures, stuff like backups. I don't know. You make sure that the data is kept securely stored, that only the right people have access to it. Things like that you have to deal with. So as long as you don't really know what you're trying to achieve, it's kind of difficult to choose appropriate measures, right? So But it's not only that. It goes way beyond that. Controllers, meaning the company, like if you have a company, you're one of them. If you are a controller, so if you deal with data subjects, with personal data, there are tons of things that you have to do. For example, you have to deal with the data subject rights. So if any person that's concerned approaches you and says, I would like access to the personal data of mine that's stored with you, you need to deal with it. Same with a copy, and I'll come to the difference in a second. The right of portability. If you have, for example, and please don't run to Reza like to Defox about this because he'll kill me when he figures out that I told you this. So whenever you provide personal data to a system like Partymeister, you have the right to have your personal information out of that system. So you are entitled to demand all your data that you entered into a system and port it somewhere else. So for example, if you have a car insurance and you want to switch the insurance company, you're entitled to get all the information that you put into the system, not everything that's in there, but everything that you provided out of it, so you can take that in machine readable format, like an XML or JSON or something, so you can go to another insurance company and basically provide them with that. I'm not quite sure what that is supposed to do, because if I was one insurance company and someone approached me with a JSON file of another insurer that doesn't comply with my standards or formats or syntax, I would kindly ask them to do something in a fire. Because, yeah, I get that you have information, but could you, no. Like, I'm not writing importers for all the competition, no. So whatever the portability is supposed to do, but that, luckily enough, that's something that they don't ask the lawyers. But so if something is wrong, you can ask for rectification, all sorts of things like that. So you deal with that. You have to prove, whenever you ask for consent, you have to be able to prove it. And just try doing that. Just go to any medium-sized, any company with a newsletter subscription model and ask them, they're probably going to lie to you, but well, no, let's put that differently. Whenever I approach any company that asks me to help them with the newsletter or something, and I ask questions about it, I can tell you that almost no company that I've talked to has ever been able to actually prove consent. It's a problem, but you have to do it. So once you have personal data, boom, right there, consent. You have to give information on the legal basis of data processing. So when you look at the privacy policy that I wrote for revision, you'll see that I'll always give a basis of lawfulness out, like why we store certain data for certain purposes. Why? So you have to do that. It doesn't matter if you earn a lot of money with it. Also, and this is just a side, it's not really a corner case, but it makes things really difficult. If you want to import a new process and have, let's say, enterprise resource planning or a digital human resources administration system, it's likely that you'll have to make a DPIA, like a data protection impact assessment, meaning it's basically an assessment whether or not it's okay to set it up and use it, all things like all the risks, all the data, all the persons, everyone involved concerned. And also, you will need to inform the supervisory authority, the SA, in certain cases in certain events. Like, for example, whenever you notice, you get knowledge of a data protection violation, you need to, of a certain intensity, you need to inform it. So, sure, some technical organizational measures can be appropriate to your little company, fine, but many of these other things are completely not appropriate to your size. So that's all in. Like, if you have personal data, you're in. There's no, oh, you shouldn't, don't call us about that shit. Like, really don't. So it's something that is actually a problem. And of course, you need to adhere to the basic principles that you've already heard, like transparency, lawfulness, purpose, limitation, all that stuff. So all that. So if we have to do all this, wouldn't it be great to know what we're doing it for? And before I go into that, and also just what I haven't at all talked about, and this is a huge frustration aspect to me and probably to everyone who's ever tried to comply with all of this, in almost no case is there, did you do it so well that criminal intention and abuse cannot fuck something up. It is impossible. If you, in any case that I've seen, I can think of scenarios where a certain person can cause a lot of problems no matter how good your backup is, no matter how strict your usage rights are, no matter how well the alarm system in the office or in the data center or in the I don't know what goes. There's always the risk of abuse, of criminal intention, and if I just try to think of how I would do it as an entrepreneur, I would think that if I do all this, if I take all these measures, if I train all my staff, if I do all this, go out of the way, spend all that money and resources on this, I would want something that's abuse and criminal intention proof. But it most of the time isn't. And that's something that makes data protection really frustrating to me, especially as an external chief of data protection, which I am for a few companies. Whenever I recommend something, they could basically say, well, what about a crime that someone wants to commit? And the thing is, yes, it's a problem. So, and especially when it comes to proving consent and all that stuff, that companies try to just take the appropriate measures. And so what that does looks pretty much like this. And this is from Imager, and I love it, just so you've seen it once. Every website in 2018. And this is a personal hatred that I feel. If the GDPR did one thing very visibly and very, very obviously, it's that you have to click away so much shit. It's awful. I mean, consent fatigue is something that doctors should be able to certify. You know, just. Like in all honesty, how many of you have even read one privacy policy in full without having a job-related reason to do it? Okay, so it's like half a dozen. Okay, why? No, I'm kidding. I honestly think the good ones should be read. It's become so bad. And I cannot actually say from the bottom of my heart that I think this has improved anything. And the worst part for me is that in many instances, I think this whole consent clicking that you see everywhere, that ruins especially mobile surfing experiences, isn't even necessary. I wouldn't go as far as openly saying it to clients, because if anything happens, they'll go, oh, you said. But it's not in the law currently. There is no law that says you have to cookie click. I'm not talking about the cookie clicker games, which of course none of you should ever play. It's awful. Don't. I'm saying the whole cookie consent stuff. It's awful. It's done wrong. I can tell you that in, I don't know, 80% of the cases. So another question: when may you process legally personal data as a company or as a controller? There are, and this is the core. I would say this is the core stipulation in the GDPR, because it basically answers the question, am I allowed to do this with data? And I'll just go through this quickly, but just so you've seen it. And this is in Article 6, it's in paragraph 1, sentence 1, and it has several letters from A to F, so 6 ones. So you may do that if you have consent, which a lot of companies aim for and run after just so you have to click on more stuff. If you need a certain personal piece of information to perform a contract, then, like for example, the address when you order something online, you don't need consent. You don't need to declare your consent that they may send it to you, because it's necessary and it makes sense, I think. Also, if you have to do something to fulfill a legal obligation, that's fine too. If you have to store data for 10 years for a certain purpose, for a certain reason, you're legally obliged, you're okay. If you have to protect vital interests, that's okay too. So if theoretically one of you collapsed and was bleeding and losing a lot of blood, we would be allowed to call the ambulance, and if we found your blood pass that said your blood type, we would be allowed to say it because we want to save your life. I think that makes perfect sense, but just so you've seen it. But in many cases, especially in everyday life, this plays no role. Also, if, and this is a corner case, but if you do something in the public interest, if your company, for example, runs the cameras that survey for the police, like a train station or something, then, and you do that legally there, you're okay. And the last and most difficult thing is legitimate interest. So the GDPR, the EU Commission, has left some room for the whole balancing that you're so familiar with from lawyers. So if I, as a company, have a legitimate interest, whatever that means, and your interest as concerned people, as data subjects, doesn't weigh heavier, like if it's the same, I'm okay, I'm allowed to do it, but if your interest weighs heavier, then I may not do it. And as good as that sounds, as many problems this creates, because then, of course, people ask, well, how can we make sure that we're allowed? Because what does that mean, legitimate interest? So in order to do that, just so you see this, there are, and just so you know, this is in recital 47 of the GDPR. A recital is something that you'll find in all the regulations and all the directives of the EU, in many cases in different laws too. But there are recitals to explain the rules in the specific law. We can, let's not discuss about why we need recitals in order to understand the law. Let's just say we do. So in recital 47, it says, it talks about legitimate interest, and it says fundamental rights and freedoms of the data subject, and right? Whenever they're not overriding, you have to take into consideration the reasonable expectations of data subjects based on their relationship with the controller. Which basically means when you have a target group whose data you want to process, and they probably expect you to do it, then you're more likely to be okay to do it on the letter F, meaning the legitimate interest thing. Now the thing is, what that to me, and I hate these cookie consent clicks, but what that meant, just so you get one example of what it means in practice, this must mean, if it says we can do it when people expect stuff to happen, well, then what we're doing just is making things even more difficult. Or as in, the more you see people doing it everywhere anyway, the more likely you'll be able to do it without consent. Which, well, that might actually be quite nice, because at some point they could just stop the whole cookie clicking thing, because everyone expects it anyway. But so, just so you see, we're educating the public in a way with stuff like that, and the conclusion for this is, as this is really iffy, many companies, especially large corporations that I work for, try to circumvene the whole reasonable expectation, legitimate interest basis entirely because it's too uncertain. They go, oh no, let's go for consent, which of course causes a new problem, because once you have consent, as you probably know, consent can be withdrawn or revoked. Meaning as soon as that happens, you're back at square one, and probably worse off, because then the whole reasonable expectation is out of the question. You're done. Like, at least that's one opinion. So, I'm completely omitting the question what you do when you have two bases of lawfulness. Like if you have, let's say you need to have it for a contract, and you need to use the data for a different purpose on legitimate interests, or maybe you want consent or you have consent for some reason, and how does the multitude of bases of lawfulness play along? It's something that there is no fixed opinion on this. And I'm just spreading mistrust here, but just so you see what I deal with on a regular basis. Yeah, I'll just leave the rest out because it speaks about careful assessment and can reasonably expect. But you've understood, I think, the basic concept. Now I'll just give you I'll just fly through a few concrete questions. What is a copy? Because you saw that you're entitled to a copy of the personal data. You are entitled to access to your data, but also, like here in Article 1, Paragraph 3, in number 1, it says, the data subject shall have the right to obtain from the controller access to the personal data. Fine. Okay. And then in number 3, it says, the controller shall provide a copy of the personal data undergoing processing. Now, in all honesty, is that, like, no one knows. Is that the same? Is that access, or is it is it an extra copy? Is that like with fries, or I don't know. No one knows. Honestly, there is literature. There are only in Germany there are various like large commentary texts on the GDPR now, as in at least a dozen, and they're like this. No one knows. They'll just go over this as if that was not a question. And yeah, anyway, okay. And how far does erasure go? Just another question that comes up. Like erasure, and I'm talking about the band. Like when people ask you to remove their data, to erase their data, how far do you have to go? Especially if you have a backup system, which you have to do in order to obtain, and to be accountable for the availability of all the data that you have to take appropriate measures, which usually includes separate backups. Now, if someone approaches you and says, I want my data removed from your stock, what do? You have to like run to the tape machines and just, what? Get sets of data out? So, in many of these questions, what will happen is the supervisory authorities will utter opinions that are somewhat practical. So in many instances, they say you don't have to go through your entire basement and delete just anything, obviously, because you can't, because it's a part of your obligation. So usually it's okay to have your backups just age out regularly. But one of the things can be just that you have to just bar it so that the information gets out of the productive system and it's just only in your backups. It's just something that people do for lack of a better solution. But it's not really conform or compliant to the actual wording. Okay, so there are certain exceptions to this. Of course, and this is only for completeness sake. This is not really important here. Obviously, if you have to store data of your data subjects legally for accounting purposes or something, you're okay not to delete it. But what can happen, like reasons of public health, all that stuff, it's fine. But ironically enough, what will happen is if there are various cases in which people approach companies and say, like with letter and everything, and say, I want you to tell me, I want access to all my data in your company, and it's a multinational company with a widespread IT infrastructure, what do? Especially if you don't have one central system to look for, which is not let's say it's not the usual case. They'll have to just spread the data in all of this and look in all the databases and come back. And in one really strange case, the following happened. It was a woman that wanted her information, and they had to go everywhere and look and didn't find anything. So if that happens to you, your company, what do you say? And the initial reaction would be to say, we have no data stored about you, which is wrong. It was correct before the letter came in. But for the purposes of the right, like complying, and you have to, you're accountable for the compliance. So you have to be able to prove that you did what you wanted. So you have to store her data for the purposes of accountability for her right to access. And before you had no data of her whatsoever. But in order to comply with this, you have to store her data and tell her, well, before you approached us, we had nothing, but now your data is in all our systems just in case you come back. It's just really odd. So these are some of the more concrete questions. Now, let's go to the underlying problems. And I know this might be a little meta, but I think this is even more important, and it's part of why the whole work with this is more frustrating to me than it probably is to you. But let's not rant. I'm trying to convey why this is important. Underlying problems. First, and just to give you an idea, this is something that we haven't really talked about, but so let me introduce to you, this is Hund. Traditionally, this Hund lives in barn, right? So, and of course I'm making a GDPR analogy, just so you know, you guessed it. So, what if Hund lived in house? We'd go, okay, Hund doesn't have to be in barn, fine, house is fine. Not barn, the dog shed. I'm sorry, I mixed it up, sorry. So what if the Hund lived in a barn, and let's say you have one. You'd go, depends. Is it a shepherd's dog? Does it have to be there for a reason? Okay. And what about coffee store? Like, does Hund live in coffee store? You'd go, well, even the most positive of you would probably say, well, why? That's a little odd, right? So, next thing, office. Does Hund live in office? I don't think so. And I'm just going one step further. Church, what the fuck? Hund doesn't live in church. So in my analogy, the GDPR lives in all these houses, and it's not even house trained. The problem is that the GDPR deals with personal data. Personal data is in. Can you? Seriously, like, you can just tell me after this, or any time really you want. But personal data affects all areas of life. What we have here is a European unification standard for something that plays into all effing areas of life, meaning all areas of legislation too. So, if that is the case, so depending on all this, everyone's concerned. And everyone has an opinion, which makes things worse, but that's a different thing. So the GDPR plays into all areas of law. For example, general personality rights, which you see when you pose questions like, well, may I take pictures of people at this event? Or my kids? Or may other people take pictures of my kids at school? What about the school excursions? Are we allowed to take pictures of them or not? Or what kind of pictures? And do the parents have to consent to something that they haven't seen? Is it, like, can you consent in advance? Right? General personality rights. Also, freedom of arts. The personality rights also include stuff like public image of a person. Sometimes you'll have celebrities that want their names or their names removed from certain Google search completions, things like that. But also the protection of secrecy. So I, as an attorney, and doctors, and there are various companies now. This is a German law, but I'm sure stuff like that must exist in other countries too. You need to protect secrets. So I may not talk about my clients, like anything I am told in the course of my work, which is why I don't. Whenever you talk to me, sometimes people approach me here and say, "Oh, here's my lawyer," and that's okay because it's their thing to say it. But unless someone specifically asks me to share information, I won't. But this has nothing to do with data protection. This is something that I need to do anyway. But it relates to persons, so it's a little bit of everything. So stuff like this had to happen, and I translated this to English. So a lawyer said, they wanted to, there was a doctor or a hospital, and wanted to invoice post-mortem services. So someone had died, and they wanted to invoice that through the what's it called, ASIP or something, like the Association of Statutory Health Insurance, Kassenärztliche Vereinigung. So it's an association that deals with Obamacare patients, right? The health insurance. If you have a health insurance in Germany, this is the association that'll take care of the invoicing. And so someone had died, and they wanted to do that, and the association said, no, we don't have consent of the deceased. And so, and I'm also not giving away there is no perfect answer to this, but they mixed up stuff. So, I mean, I can tell you that this is not okay. Like, what they did is not okay. Like, data protection is something that has nothing to do with, like, deceased people. Once you die, you're done with data protection. You're not done, though, with this. So, as a doctor, you have to maintain secrecy, and it's just a mix-up of stuff. It just makes things really complicated in certain cases, like this one, and it just becomes really bizarre to the open public, and I mean rightfully so. So, and to make matters a little worse, you're holding tight. I love that. To make matters a little worse or a little more absurd, this is what happened before the GDPR came, and I think this is the main reason why companies did stuff like dealt with data protection, is because they were afraid of the fines. They could be fined with as much as 20 million euros or up to 4% of the net worldwide sales, whichever was higher. And then this happened. This February, this is again a German thing, but it could happen anywhere. So the German Federal Cartel Office, the FCO, fined Facebook for collecting data, among other things, but for collecting data from third-party websites without the consent of the users. And that alone is, I think, a GDPR thing. It's a GDPR violation, and it's correct that that is not okay. But it is not at all a cartel thing. Now, if you ask, what's a cartel antitrust thing? I'm sure you're familiar with competition laws. And competition laws are basically laws against the hatred of companies or among companies or between companies. So if you want to get ahead of your competitor and you want to like push them aside, that's what company laws usually deal with. The cartel does the exact opposite. It deals with the love between certain companies. So if you can get a certain market share, and it's happened with Microsoft a couple of times that they delivered their Windows with Explorer and you couldn't get it out. That was a typical thing, like a typical thing for the antitrust cartel. And the fines that they get from there are much higher. In this case, it was 1.5 billion euros, which is a little more than this. Just for comparison, and this is a completely different thing that happened. They're not at all related. I'm just comparing. I'm just giving you this because it makes a little clearer what GDPR has done so far and what now cartel authorities do, like without blinking. The highest fine issued by any European data protection supervisory authority has been, at least it was a week ago, I haven't heard anything else, has been 50 million euros issued by the French Supervisory Authority against Google, also for not being transparent on their consent terms and things. But just so you see, like that's 50 million right there. It's a ditch in the stock market for Google. They couldn't care much less. But just so you know, it's quite a lot of money, but it's nothing in comparison to what the cartel authorities do. So, and also, now among lawyers, we've discussed quite a bit what right it even was for the cartel authority to issue this for data protection reasons. Because if it is without the consent of the users, that alone is not something that the cartel supervisory authority would even be competent for. So it's very odd. There are many things happening. So if you're unhappy with the GDPR so far, I can tell you you're in good company. So And this is something that we could be discussing forever. I'm just looking at, okay, I have a little more time, fine. This is one of the core problems that that's greatly discussed among lawyers, but it is, I think, one of the most important questions. Now, as you've heard, a lot of people have obligations now under the GDPR, but what the hell is the GDPR even trying to protect? Why are we doing this? And I've talked to various of you in the course of this party, and everyone has a certain scenario that they have in mind and that they want to prevent. They say, in that case, it's kind of, isn't it important that we? And usually the answer is yes. But when you see all this in the area in which the GDPR plays, which is everywhere, I think it's quite important to figure out what we protect. So what the GDPR does protect, at least with regards to what's in it, what it says, is things like fundamental rights and freedoms of natural persons, and in particular their right to the protection of personal data. Okay. Not okay. Because, you know, I get it, but like fundamental rights and freedoms, okay. And in particular, their right to the protection of personal data. So we protect data in order to protect personal data. Okay. Not okay. So, and what Article 5, which you have already seen, says personal data shall be kept in a way that safeguards the rights and freedoms of the data subject. See, we're turning here. And in Recital 1, the recitals in front of it, paragraph 2, in combination with Article 8 of the, I forgot a reference here, of the European Fundamental Laws Charta, everyone has the right to the protection of personal data concerning him or her. Okay, I don't feel like we're moving here. So let's look at what the GDPR mentions often, or at least mentions at all, as goals. So 77 times you'll see fundamental rights and freedoms. Okay, not helping. Free movement of personal data is mentioned 21 times in the GDPR. So free movement of personal data, okay. But with the data minimization, very odd. Also, it mentions internal market. That is a goal, that's what they're protecting, fine. But what it hardly or not at all mentions as a protective goal is control over personal data. It happens 3 times, but okay. Control over personal data, which I think is an illusion. It doesn't really exist, but that's something to discuss over. Also, private and family life. That is something that is mentioned at least once. Home and communications, okay. Okay. So, if you're thinking, okay, now, is this part of the definition of personal data? The answer is no. And what is not at all mentioned is privacy. Never. It is not in the GDPR. Privacy is not something that it, at least explicitly, tries to protect. So, what's what? Now, even with data protection and privacy, what's what? I've tried to figure it out, and honestly, I don't know. I don't know. Because sometimes you'll see stuff like this. On Ipswich blog, it says, in a nutshell, data protection is essentially a technical issue, whereas data privacy is a legal one, which is bullshit. On thepayers.com, I found, in a nutshell, the GDPR combines data protection and data privacy principles and puts individuals back in control of their data, of how their data is used, which is bullshit. So, yes. And also, this isn't even helping because it just mentions both. So, okay. So, if either of this were true, why does the GDPR never mention privacy as any of the goals? I don't know. I don't know. And to make matters a little worse, and I'm omitting this too, is I'm not sure if who of you has heard that there's an e-privacy regulation coming up? okay? So that is basically, it's not quite true, but it's true enough. It's the new cookie clicking rules. It's very unprecise, but this is what everyone is looking for with regards to what cookies we may set with consent and without consent. And in this, it's even more bizarre, because it talks about privacy, but then it looks not at persons, not at data subjects, but at communication devices. It's very odd. No one really knows how to combine these two things yet, and I think it's just getting worse. And now, in order to give you a little bit more information on why, like when this can be relevant, we're all doing this because we want to be safe when the supervisory authority approaches us and wants information, or wants to fine us, or something like that. So what do you have to do in order to comply with the GDPR in general? Well, you have to deal with things like, what legal basis do I have in order to process any or collect any personal information in any single case? So the Article 6 that you saw previously, with the 6 letters from consent to legitimate interest, is something that you have to talk about, like think through in any single case you want any personal data. Also, you have to ask yourself, how far do you have to consider criminal intent of certain individuals? Like, it could be just interns, it could be any person in your organization or outside, and I'm not even talking DDoS attacks. I'm talking any scenario where it's criminal intent. And also, what do you do? And I haven't even talked about what supervisory authority is competent for each case, but what do you do if your supervisory authority hasn't uttered anything on that matter? You want to, I don't know, set up a certain IT system in order to process certain personal data, and your authority hasn't stated anything on whether you have to do a data protection impact assessment, what technical organizational measures are required, whether you have to report anything, in what instance you have to report anything to them. What do you do if they haven't talked about that? And what, to make matters even worse, what do you do if your authority hasn't said anything, but other supervisory authorities have? Like, let's say you're in Saarland now, and your authority hasn't said anything, but the Hessian or the Bavarian or the Hamburg one has, because they're not competent. Like, it's not their issue to deal with you. So what do you, like, and I can tell you that if you do what another authority says you have to do, and then your authority approaches you and fines you, you have no right in saying, but I did what the other one wanted. It's likely that the fine will be lower, or if you at all get one. But there's no way you can get your money back from the other authority or the state because they said something wrong. And now, of course, what do you do if your authority is auditing? What do you do? So should you, like, 2 minutes, should you comply? Should you not comply? Should you stay silent? What do you do? And also, what if the information that you give to your authority is something that can result in a fine? Like, if you have to self-incriminate yourself. In Germany, that is fundamentally forbidden. You don't, or at least you can, but like, if the police shows up and says, what else do you have in your basement? You don't have to tell them that you have stuff, if you do. You also don't if you don't, but so what about that? And also, how does the authority combine all their tasks and obligations? Because they're supposed to advise you, they're supposed to audit you, they're supposed to fine you if you do something wrong, and many other things. But how is that supposed to work? You might even have approached the authority saying, hey, I would like to set up a certain system, and I don't know what to do with regards to a certain aspect. Like, right now, this is what we do, this is what we'd like to do, are you okay with that? The next thing you know is the supervisory authority sends you a letter saying, next Monday we'll be on your doorstep, just get your records ready. They find something, and then what? They fine you? It's a huge problem, and whenever I listen to people from supervisory authorities, they say, well, we're aware of the problem, and of course we're not doing that. Of course, if we advise, we don't fine. but there's nothing like that is ever in writing. So it's quite difficult. So to conclude this, and I'll need another minute, I'm sorry, what have we learned by now? First of all, data protection kicks in whenever there is personal data. It's just like that. Not all of it, but almost all data is. The requirement of transparency becomes more and more difficult as we have to click away stuff, and everyone's really cautious, so they're getting consent for just about anything. Even if they do it wrong, they don't care. They just do 2 extra steps rather than none, which annoys the shit out of everyone. And also using legitimate interest as a basis is really complicated for various reasons, amongst which also is that people can withdraw their consent, and then what? Data protection, without the S please, is an omnipresent yet very indistinct phenomenon that none of us can actually really grab or define. And it, even when it comes to bordering with privacy, it's just really indistinct, and which makes it very, very difficult to even get an idea of what we're doing this for. And also, it's really difficult, of course, for any company to comply with the GDPR also, because the rights, the whole discussion on rights and freedoms of data subjects can completely go out of hand without you having anything in writing in the GDPR that prevents it. Even the GDPR is really diffuse, like really indistinct about what it's supposed to protect. And last but not least, dealing with supervisory authorities can be a tightrope walk, so you have to be careful. There are experts on helping you if you ever have that. But it's a vast topic that I hope you find interesting. I'll be here. Talk to me if you have opinions, if there's something that you would like to know that I forgot here. And I hope I could enlighten you a little bit as to what is problematic and when you deal with it, and also more on a meta level than just like concrete questions on how long do I have to store things. Thank you very much. Hund and I thank you for your attention. Now, no, okay. Now, certain important people are shaking their heads in disbelief. I'll be at the bar. Please come to the bar with me.